How can you get released from a law school early decision agreement? Imagine you got into your dream law school through early decision, but then life throws a curveball. Maybe a family emergency, a serious health issue, or a financial crisis pops up. You might wonder if there's a way out of that binding agreement. Well, let's walk through what actually can get you released from an early decision contract with a law school. First, it's important to know that most early decision agreements are designed to be binding. That means if you're accepted, you're expected to attend and withdraw all other applications. But there are a few situations where you might be released. The most common one is if the law school denies your application or puts you on a wait list. If that happens, you are no longer bound and can explore other options freely. Another way to get released is if you have been admitted but face unforeseen circumstances that make attending impossible. For example, if you experience a serious medical emergency, a significant financial hardship, or a family crisis, you can request a releases. Keep in mind this is not automatic. The law school will review your request and decide at their discretion. They might ask for documentation like medical records or proof of hardship. If your admission was conditional, say, it depended on final transcripts or degree completion, and you do not meet those conditions, the school can revoke your offer. When that happens, you are no longer bound by the agreement. Some law schools allow you to withdraw before you actually start classes. To do this, you usually need to submit a formal written request and get approval from the admissions office or dean. Be aware that withdrawing after accepting under early decision can sometimes hurt your reputation with the law school or other schools if you reapply later. Most schools do not permit deferrals under early decision. So, if you want to delay starting for a year or more, that generally isn't an option. If you find yourself in a situation where you need to be released, it's best to act quickly. Contact the law school honestly and provide any supporting documents they might request. If they agree to releases you can then apply to other law schools. But if you attend another school without being released, the original law school could revoke your offer or notify other schools, which might harm your chances in future applications. In the end, getting released from an early decision agreement is rare and usually only granted under exceptional circumstances. It's very important to think carefully before applying through early decision because it's meant to be a firm commitment. Planning your application strategy with this in mind can save you a lot of trouble later on.